Um, Hello, everyone. Welcome to the webinar, Social Distance, Indo-European Business Relationship and Cases Resolution through Mediation, organized by AK Partners and supported by Embassy of the Czech Republic in New Delhi. I am Siddharth, Manager at the Center for Mediation and Conciliation, and it is an honor for me to be moderating this enriching session with the esteemed panelists. I'm thankful to AK Partners and Embassy of the Czech Republic for extending this opportunity to me. Now, we all are going through this time of uncertainty, and while adopting preventive measures to overcome the pandemic, we are laying a new roadmap for the world to function. Social distancing is the new norm, and the whole world is reevaluating their strategies to build their resilience and move forward. And as we move towards a new normal, we will be faced by novel disputes for which we need to build preventive mechanisms to handle them efficiently and effectively. In today's discussion, we aim to talk about upcoming opportunities, emerging disputes, shifting of investments to India, and finally renegotiating contracts and dispute resolution. Let me tell you the format of the webinar. It's pretty simple. We will be having opening remarks from His Excellency, the Ambassador of Czech Republic to India, followed by a fireside chat with the speaker panelists, followed by a question and answer session from the participants in the last 15 minutes. And we will end it by concluding remarks and vote of thanks by His Excellency. As I've been hosting multiple webinars for CMC, I have a small request for our panelists. It's a very small and sincere request to mute themselves when they are not speaking, because it causes a little bit of echo and disturbance. And I request the host to help the panelists whenever it is required. Thank you. I would request the participants to please send in their questions to the panelists in the chat box available to you over the Zoom during the panel discussion, so that we can line them up without delay for the Q&A post-panel discussion. Please also mention your name, designation, company you represent, and the panelist's name in case your question is directed at a particular panelist. Now, it is an honor for me to welcome His Excellency Milan Hovorka, the head of the Embassy of the Czech Republic in New Delhi, and the Ambassador of Czech Republic for 6 countries, namely India, Bangladesh, Bhutan, Maldives, Nepal, and Sri Lanka. I welcome Mr. Jeremy Lack. He's an ADR neutral with CEDR, ICC, JAMS, SIMS, INTA, and WIPO. He is registered at bar at Geneva, England, and Wales, and the USA. He's an expert in international multi-country mediation, negotiation and transaction facilitation, and regularly advises on perspective talking, reality testing, option generating possibilities, and how to prepare for 7 critical junctures on a negotiation. And last but not the least, I welcome Mr. Anuroop Omkar. He is a corporate and commercial lawyer and ADR neutral. He's partner at AK Partners, mediator at CAO World Bank, special expert member of Working Group on Insolvency with Insolvency and Bankruptcy Board of India. He's a trainer at Indian Institute of Corporate Affairs Mediation Training and the author of a bestseller book by LexisNexis, The Art of Negotiation and Mediation, Wishbone, Funny Bone, and a Backbone. I would like to mention that Mr. Jeremy Lack and Mr. Anuroop Omkar both are also CMC's esteemed mediators. I welcome you all. I would like to welcome all our participants attending the event via Zoom and those watching it live over Facebook. I would now request His Excellency Milan Hovorka to take it further for his opening remarks.
Good evening. Can you hear me?
Yes, yes, sir.
Good evening from New Delhi. Bonjour à Genève. And definitely good afternoon or good morning, even depending where you are in the world. And I trust that you and your loved ones are safe and secure in these trying times. And I would like to express my gratitude to our partners for today from International Mediation Institute, AK and Partners, and the Center for Mediation and the Conciliation for giving us the opportunity to team up and organize together today's seminar on what I believe is quite timely and increasingly important subject. And definitely great to have you all with us. And thank you so much for the interest that you have shown and the time taken to be with us. Looking at the invitation to the seminar discussion and also listening now to me, one may ask, why an ambassador? Why the ambassador is taking the lead to organize this kind of discussions? And I will tell you, it is quite simple. I like very much the subject, and I trust the essence of mediation. And as a seasoned diplomat who has been in the shop for more than 35 years, representing the country also to the World Trade Organization as the ambassador, I can appreciate how important is it to be able to talk to others, to listen to them, show willingness to find middle grounds, and solve any eventual problems through dialogue and a commitment to work through differences. And then again, one may ask, why the ambassador of the Czech Republic? And I will respond also this question. And again, the answer is quite simple. We contextualize today's debate over Indo-European business relationships, something that is very close to my heart, both in professional and personal terms. And you will understand it is extremely interesting for someone who represents a 10 million nation to perform in a 1.3 billion India. But the question here is that it is not about the size. It is about certain commonality of values, mutual respect, positive mindsets, and feelings of sense of purpose. And being a representative of the proud member of the European Union, it adds additional dimension to my diplomatic efforts, and I have to say, extremely rewarding dimension. And when talking about Europeans and Indians, I believe you will agree with me if I say that we are natural partners. We have proved our capacity to work together for jointly shared prosperity and humanity, bilaterally, regionally, multilaterally. And we have shown a capacity to show leadership in finding proper answers to certain pressing global challenges. We have been developing a thriving trade and investment relationship. And today we are united in the global fight against COVID-19 pandemic, which undoubtedly is one of the most unprecedented challenges in living history. In whatever terms, whether we talk about health challenge and the imperative to counter and contain the pandemic, or we focus our attention to the prevention challenge. Here I talk about our preparations for the next phase of pandemic. Or let's talk about the financial challenge and the need to ensure adequate financial resources to be able to protect people's life and build more resilient health security system. And finally, and getting closer to the essence of the seminar, COVID pandemic poses enormous economic challenges and threats. And I believe to be able to deal with them and to minimize negative impacts, we have to keep our borders open to ensure fluid flows of all medical supplies. And here I can't but mention what India has done to contribute. Definitely, I do have in mind that the tremendous decision to send critical drugs like paracetamol and hydroxychloroquine to more than 100 countries. But I would go on to say that it's not just about medical equipment. It is not just about essentials. It is also about non-essential goods, and it is also about services. And we have to stand firm not to allow any protection to dictate our respective trade policy or economic agendas. And I would say that a kind of standstill is the name of the day. And I believe that, again, European Union and India are ideally positioned to take the lead to enable timely economic recovery through commitment to renewed multilateralism and global partnership. And whether we like it or not, it is almost certain that in this scenario of full of uncertainty, instability, and unpredictability, we are likely to face a substantially increased numbers of different kind of disputes arising from the COVID-19 crisis and inability of partners to comply with their contractual commitments. And businesses will have to deal with a number of issues related to quarantine, business closures, different kind of restrictions, including travel restrictions. They will have to find a common ground when it comes to concepts like force majeure or impossibility. And there the question is whether the litigation, the process of bringing the case to the court, that the judge can take a decision, is the only one, or whether there are any other ways and means to sort out the differences and to search for amicable and agreeable solutions. And I believe that there are others who can discuss or answer these questions in more eloquent and professional manner. So I would maybe stop here. Definitely, I'm staying with you. I'll be more than ready, happy to take any question. And in the meantime, thank you very much once again for giving us this opportunity to work with you. And definitely, thanks to all for listening to me. Thank you very much.
Thank you. Thank you so much, Your Excellency. Now I will, as he rightly said about the pandemic and how how the pandemic has spread more because of the globalization. I would start and I would ask the first question, and I would request Jeremy to answer it first and then followed by Anuroop. Like in the 1990s, the entire world was transfixed with globalization. And today, the entire world is a maze of connected dots, which is unfortunately how COVID-19 spread. But the European Union has now rolled out measures to promote local economies and self-consumption. Similarly, the Indian government has rolled out a campaign for Atmanirbharta or self-reliance by promoting local industries. On one side, localization, and on the another side, foreign investment. How will these objectives balance out going forward, according to you? Jeremy.
Well, yeah. I think we need to look at this in two contexts. First of all, at an economic level, and then if we're focusing on disputes at another level. I think more generally, globally, I think we have to think locally. We can't think globally. we can't think locally, we have to think globally. And the reason for that is that the old world paradigm is still this notion that we live and work in countries, and the COVID-19 crisis has made it very clear, even within the EU, how much borders have automatically come back. I think that's just a reality we need to understand and accept, but it's very unusual times. So let's try and take it outside the COVID-19 pandemic. I still think that we need to think along both levels more so. We are used to thinking about the world as the largest economies as being countries. But if we look to the future, the largest economies of the world are rapidly becoming multinationals and corporations. Now that creates many issues for access to justice. It creates many issues for what are the laws that apply. But if you look at how many citizens are there in the world of Facebook, we are almost one of the largest countries in the world. And we're not talking about even economic assets there, although that is an issue as well. And when you are a small software company, and I have the great pleasure of dealing with some companies in India, and the technology is outstanding and amazing with what I'm seeing. It has two problems. It has obviously to overcome the local issue. What are local laws in India? What are international laws, and how do you manage these things? But then there's also the aspect of whatever the contract is, making sure that it is understandable and enforceable. And that is where I think the global system has broken down. Clearly, we have a Hague Convention, we have the New York Convention for Arbitration, and we now have, hopefully, the Singapore Convention for mediated settlement disputes. However, we know the European Union, for example, has not signed it. And we know also, for example, that even Switzerland, where I am, and I'm very embarrassed by this, has not signed it either. And so there is some fragmentation in our logic. I think it's also a result of some of the current leadership we're seeing in the world, not to name any specific countries and places, but there is far too much emphasis on nationalism in some places. However, the fact is that for the average company or person, I think we can't go one way or the other. We have to accept that the world is global, and that's how it is.
Thank you. Anuroop, how about in the Indian perspective?
See what taking a cue from what Jeremy said, in a way it's a global world, but in a way it's also a local world, because we have gone really far now in a way how we trade within among ourselves, what we import and what we export. But we need to again understand, whether it is in context of Europe or it is in context of India, a lot of concepts may be global, but when it comes to execution, when it comes to ground level performance, it will have a bit of local flavor. So we need to, work on concepts which are global, because the world is now a village. The world is like entire world is like a country. But at the local level, we need local expertise to ensure that whatever is the global concept, that reaches the finality. So I don't think anyway what India has rolled out or what Europe has rolled out is anyway going to affect. And, at a personal belief and optimism, I believe COVID has to go away. Yes, it's a very trying time, but once it is gone, things will take a little time to stabilize, but it would run as it is, but with a little bit of twist, maybe a little more work which was being carried out global will be done a little more in a local manner. And a lot of things which were running much local at the concept level will be kept at the global level. But I don't see any conflict between both the existing concepts, because I think for ages together now, global and local has been existing, because even after the Indian liberalization and globalization era, it's not that we did not work on things at our end. We did. But maybe we looked up to Europe, we looked up to US for investments. We had our own indigenous technologies or indigenous medicines, but to maybe market it better, to get it to the global platform, we again sought for investments, right? So if you look at, the statistics, in Europe is the largest single trading partner for India. So we can't really cut it and say, everything becomes local or everything continues global. There will always be an interchange. inter-exchange between what is global and what is local.
True. Following this, now I would ask this following question to Jeremy. As you rightly said about this term local, like with local laws and international laws, many European companies are considering shifting their manufacturing bases to India. And India is already in the process of harmonizing and simplifying its labor laws. What other factors are important for European investors, in your opinion, when shopping for a supply chain jurisdiction?
Okay, you're putting the context of supply chain jurisdiction, but for me, that's a much more narrow category. At the end of the day, it's people and it's relationships and it's long-term trust that is what is going to matter. And so, first of all, there's a barrier distance. Obviously, people think of India, I think, both in terms of costs, ingenuity, and people thinking in a way out of the box. There is a lot of different new approaches and new thinking that is happening in India, and it's a very exciting time in many industries. You talked about healthcare. There's a revolution, I think, also happening in the pharmaceutical industry, simply when you're looking at generics and how that is being done and new approaches to treatment. And I'm not just talking about pharmaceutical kind of traditional healthcare, but alternative or general wellness forms of healthcare. And that's a big export, it seems to be also from India in many areas. So for me, what is going to entice people to do business in India? It's not just the labor and it's not just the cost. It's a much bigger package of things. It's going to be, first of all, the relationships, the access. There is obviously the framework of law. And that is, I think, where there is currently a perceived risk for many people. The speed, so I had the great pleasure, Anuroop was with me 2 years ago. We were in Chandigarh meeting with members of your Supreme Court and Court of Appeals. And you have such venerable and esteemed judges in India. However, they themselves, I think, are realizing that the system needs to change. Because getting access to justice is not just about the money and the cost and the lawyers, it's a matter of time. And justice delayed is justice denied as much as anything else. And that is a current reality. So I think already, not only do we have these traditional problems of time, but then if I look at the current evolving world of startups and new technology companies, 3 months to 6 months is equivalent of 5 to 10 years for them when we were growing up. So already what seems to be very fast, because 360 days in most countries to resolve a case at first instance would be seen as extremely efficient. However, when it comes to commerce, I think that it is far too long. People are looking for resolutions of disputes within 3 to 6 months. We do not have the infrastructures in most countries. This is not an Indian phenomenon. This is as much a Swiss or a Czech or an EU phenomenon as anywhere else. How do we provide access to justice that is fast, cheap, and able to respond to the timelines and the needs of businesses? That is where I think our problems lie for future trade, future growth, future investment. So I'm not saying go to a country based only on its laws and how to resolve disputes. That would be absurd to suggest it's a primary factor, but we do know from investor treaties how much capital will go into countries and how people will avoid putting serious capital in countries where there are risks. The other area where I do think there'd be an issue for me from past experience in India has been with intellectual property laws. Some countries are nervous in some areas, thinking how is Indian law going to protect, not just in terms of the time it would take if there is a dispute, but even in terms of the nature of this. Some pharmaceutical companies have been very nervous about the scope of patent applications, what's coming on. And I think we are facing two much broader issues, which maybe His Excellency can comment about from his work at WTO. But if we are moving towards a world where we have artificial intelligence, and we have a world where we have more and more computers who will be doing innovation and writing source code or writing text without a human being behind it, we will no longer qualify for copyright protection or for patent protection, because the element of a human mind is a requirement for both of those IP rights. So how are we facing a future, and how will we look towards a future that is more and more dependent on technologies, in a system where we don't only have difficult systems for resolving these conflicts that are inefficient for the needs of the market, but even so, the substantive norms behind it for what is protectable and not protectable are not sufficiently harmonized. And we can point to WIPO, or we could point to WTO, we could point to WHO, depending on the area and the field. But I think that is another problem that we have, because it's all about technology these days. The value of most companies today, 80 to 90% of their valuation lies in their intangible assets, no longer in their tangible assets. So I think these are far bigger concerns and considerations, especially for me, for a country like India, when I look at it. And I'm very concerned about some of these issues for the future, but it's not specific about India. I think in Switzerland, we face many of these same problems as well.
Anuroop, as Jeremy also mentioned about multiple sectors, he mentioned pharmaceutical, hospitality. Now, what are the sectors do you think that shall see a boom in terms of foreign investment, both from the perspective of European Union investment in India and Indian investment in the European Union?
Okay, so let me break this into three different parts. Part number one would be what has been the area of investment by European Union per se in India. Which are the sectors I see a boom in based on what has happened in the past? And the third part, which, again, what Jeremy pointed out, how do we, streamline our contract enforcement system, both at the judicial as well as the non-judicial level, to ensure that the investment does not only happen based on the concept, but also happens based on the governance standards or the judicial standards of the country. So, I was doing a quick research before the webinar to see what kind of, trade has been happening. Primarily, I'll put some interesting facts before you. For last 1 decade, the trade and commerce between European Union and India has grown by 72%. Starting from 2003 till 2019, the kind of investment that European Union has put in India is more than 107 billion US dollar. Further, more than 6,000 European companies are in India, giving employment to 1.5 million population directly and more than 5 million population indirectly. So it clearly shows the intent of European Union to invest in India. Now, talking of sectors, what they have been investing primarily has been chemicals, mostly barring fertilizers, but something like agrochemicals, micronutrients, pesticides, insecticides, which suits the Indian standards, because the European standards of tastings are a little different. They have been also been heavily investing in life sciences and pharma. And also a certain portion has been in infrastructure and technology companies. But what has been seen as a primary trend, that Europeans prefer to invest in brownfield projects rather than greenfield, and which equally works for India investing in Europe, because India put together till date has invested, I think roughly what I can recollect is more than 82 billion USD, out of which only 15% has been greenfield projects. And out of that greenfield projects, it's only the India's biggest corporates which have gone, including the Tatas or your ONGC or IOCL, who have invested in Europe. So what I see a surge after this possibly is the hospitality market is bit drying up, because per se they were not on a very high profit margin in India. That's an area where I see, because Europe is very much deep rooted within the culture of travel and tourism. So I see that sector in India booming based on investments from Europe, which does not just bring in money, but also brings in strategic partnership of architecture, world-class infrastructure, the global standards of, hospitality. That's one sector I see a boom. Definitely, pre-COVID, what was talked about is the 5 trillion economy. And in return, it is giving a boost to the infrastructure sector. So that becomes an obvious area of investment for European investors. And again, what Jeremy pointed out, we anyway supply the global workforce when it comes to technology. So because of, going to the first question which you asked, because of a little bit more of localization, I see a surge of investment in the technology sector as well in India. However, let me just quote the former Chief Justice. I heard him in a speech, Justice Gogoi. He said we need to completely revamp the legal system from the grassroots level. The reason being, even I would put myself in that category. I'm trying to evolve and learn. We understand the civil procedure code much better than what mediation is. We are so deep rooted into the legal learnings through the law school and practice, we tend to apply law to everything rather than understanding it's about human emotions and relationships. So India needs to come up with a more robust, I think since 2018, India has been doing changes to the dispute resolution mechanism in bits and pieces, bringing in mandatory mediation, bringing in company mediation, bringing in consumer mediation, even going on to bringing in contract enforcement, pre-litigation mandatory mediation. But we need to see the implementation. And I don't see the implementation happening the way it's presently going on ad hoc basis. There have to be institutions of repute, institutions capable of spotting the right talent in mediation, institutes capable of providing regular learning in terms of dispute resolution based on global practices, and institutions which have the credibility for parties to resort to, and more so, let's put it, international parties, when they are in a state of conflict or crisis, and it becomes convenient for them that they just file in an application with an institution, then the institution should, roll on the red carpet for carrying out the process of conflict resolution. Maybe mediation, maybe hybrid, or even arbitration. Like, I'm not trying to say it's only mediation. Some matters are very well suited for arbitration. So, these are the three parts where I think if we work and improve, we see a lot of European investments into India and the vice versa as well. But on the European side, they have wonderful institutions. I think a couple of them Jeremy is a part of. So they have been doing their bit. It's now time for India to do its bit.
As you rightly said, there is a need, as quoted by Justice Gogoi, that there is a need to revamp.
May I just jump in and add something, Milan?
Yes.
I know you are absolutely right, and I agree with the list of sectors. But I would like to underline that it's just not about certain specific sectors or economic activities. That it is about a concept. It is about the willingness of the European Union and member states to build a strategic partnership with India in a number of fronts. It is about the genuine interest in participating in India's modernization efforts. And definitely, while talking about modernization, we do have areas in which we can gain a lot if we redouble our efforts. I have in particular in mind clean energy, climate partnership. We do have a number of partnerships, including water partnership. We are working together with to deal with pressing issues related to urbanization, circular economy, yet another quite important area in which Europeans are interested in working together. And definitely we want to invest into the future. R&D and innovation. These are other areas in which we have been promoting. And I can tell you, also as a representative of the Czech Republic, we have done a lot to help Indian researchers, institutions here to tie up with their Czech counterparts with a view to inventing and working together. So I just wanted to elaborate a bit and add that it is about certain principle fundamentals and really the genuine interest of the European Union to participate in those strategic policy orientations in India. And then definitely there are also certain traditional sectors, like, for example, automotive. And here again, we understand what is the way to be successful in India. It is not about to build your relationship on a supply basis. You have to come, you have to invest, you have to bring your technologies, and you have to convert India into your place into place where you want to develop your business activities. And from that perspective, I believe we are also doing extremely well. And definitely, I think that Anu is absolutely right. We are equally interested in having Indian investors in Europe, and I would only encourage my Indian friends here to do more, to travel more, to come and not only talk to us here in New Delhi or in India, but if they travel, hopefully it's maybe not possible now, but once the pandemic is over, I believe that we will be able to redouble efforts with a view to explaining or showing our talent. And the best way to understand it is to travel and meet us in Europe. Thank you so much.
Thank you so much, Your Excellency. I loved your comments like that, make it your home and not just invest. Anuroop, coming back to the point, as you mentioned that, there is a need to completely revamp the justice system. I would like to ask this question to both you and Jeremy. Like with the increasing and also personally, I feel that mediation is the upcoming thing now, especially after the Singapore Convention. So with the increasing number of contract breaches, renegotiations, and a heated discussion on force measure, do you think mediation has suddenly become relevant, or was it always the first resort that businesses should have opted for? And what are the benefits of using mediation for business?
Okay, Siddharth. So let's put it this way. I have sent more than 70 plus notices to different counterparties based on instructions. I must say, based on instruction of my clients as a force majeure notice. But I hope no one holds me on this. I find force majeure little overrated. Because when the entire world is in a chaos, how many force measures do you trigger? Because it's nothing but a spiral and a cyclic effect, right? So it's not like one country is affected and the rest of the world is fine. So I personally believe force majeure has been little overrated. And coming to your specific question about mediation, I think, Jeremy would be a better person to answer when it is about Europe. But my personal experience pertaining to Europe has been they have embraced it long back. Like I think 2008 European Union directive talks about mediation. We have been again a little late in holding on to the strings of mediation, but it should have always been there. As in, let's not talk about it as a profession or as a practice mechanism. It's inherent within human to resolve conflicts. It's not like any one of us loves to be in a state of conflict, or all of us love to have that adrenaline rush of arguing in a court. It's inherent, but what has happened over a period of time is we have been trying to codify it and bring it into formal structure. So I personally believe mediation has been happening without a neutral mediator. Now what is happening is mediations is being done in a more professional and institutional manner with a mediator. That's point one. Point number two, talking about benefits, I think it will be too cliche to keep on saying that, it saves time, it saves money, it saves relationship. I personally believe now in the times of COVID, it allows you to move further. It allows you to reinvent things because things are stuck in a manner where no amount of conflict can resolve it. It's only thinking out of box, thinking creative, and thinking of future, you can resolve a conflict. So I personally believe it was always time for mediation. now possibly, fortunately, at least I can talk of India, people are enjoying the process of mediation, willing to adopt mediation, and people are genuinely sending queries, including a couple of my clients. Can you give us a standard clause of mediation? Like I always say, it's not a very politically correct statement. India gives a treatment to mediation as a stepchild. Now we are also one of the primary child, both of the judiciary as well as the corporate world.
Very true. Jeremy, what would you say? Like, was mediation always relevant, or has suddenly become more relevant?
Well, I'm going to be a bit more nuanced on this, because I think it's the matter of the grass always looking greener on the other side. We have, yes, in Europe, a European Union directive on mediation. For me, it is completely ineffective, because what it has led to is, again, coming back to our first discussion of localization versus globalization, it has simply led to that in every single member state of the European Union, every country has legislated mediation in its own domestic rules, and with different laws and different understandings of even what mediation is about. In some countries in the EU, you have to be a lawyer to be a mediator. In some countries, has to be regulated by the judiciary. In some countries, you have to be kind of accountable to the legal system of the jurisdiction you are in. And if the idea of Europe was to create free movement of goods and workers across borders, we've done the exact opposite. We've made it almost impossible for a German or an English mediator, well, let's put Brexit aside, that makes things too complicated, but let's just say a Dutch or a German mediator to be able to go and mediate in Italy, because they do not now fit within the system. And if you look at the statistics on mediation in Europe, I find them very depressing. There are some notable exceptions in Scandinavia. I think Netherlands is a real kind of beacon for what we are doing in Europe. Other countries had moments. Slovenia had different moments, had under its Minister of Justice, Darko Horvat, had a real kind of impetus of how can we change things. The United Kingdom, yes, I think that mediation has definitely grown tremendously in the UK. However, I think it's more a response to the cost systems and some of the other strategic issues of the common law system. But I'd say on the whole, it's not working. And if I look at Italy as an example, Italy is the only country, I think there might be another one, that has put in mandatory mediation. In other words, you cannot get to the judge to hear your case without having had at first an information session and an attempt at mediation. And this was so polemic in Italy that they even went on strike, and the law was actually declared in a void and of no effect, and they had to go back, and a new law came back. Now, it's really interesting to follow the statistics of what happened in Italy before the new law came in, after the new law came in, what happened when that law was then voided, and then when the new law came back as it currently is now. Italy today probably has more mediations than the rest of Europe combined. And so that is the reality. Roughly 200,000 cases is my understanding per year, which is nothing. It's when you look at their court system also, and if you've been to Milan Chamber, Milan Court of Commercial Justice and seen some of the queues and what is happening there, it's the same phenomenon as I'm seeing in other countries. I have judges telling me in Brussels that they sometimes have to listen to 300 cases in the morning. This is access to justice also is a real problem here. So I do think grass is always greener. Now, if I look to India, my understanding or my perception of it is there was real concern about who can you abdicate control of the judicial system to? Can we trust private sector mediators, or do we need to control this? Do we need to have court annex schemes? Do we need to certify and mandate our own mediators? And I think there's huge confusion about what mediation is in the first place. Is mediation a matter of somebody who's an expert in the law coming in and using norms, legally shaped norms, to kind of help people understand what is the zone of possible agreement applying these legal norms? Or is it a form of completely subjective justice where people can really exchange information only about their subjective needs and interests into the future, find common ground, and then use the law, but only as a benchmark to see how well does my solution compare with what the law might have given me. More often than not, a lot of the people I speak to, and this has happened in a lot of European countries, we sometimes use the word conciliation versus mediation to reflect the distinction, but there is huge confusion where people are thinking it has to be a norms-based process. You need to have court-annexed experts, and they are the ones who need to be controlling or running the show, because God forbid, we will have a system in place that is uncontrollable. So I think there's still a lot that's misunderstood about dispute resolution and what is mediation. I think that Ken Cloak wrote an article, Let 1,000 Flowers Bloom. We certainly have at least 12 or 20 different forms of mediation in one country alone, I would say. A study done by Manon Schoneville that's called the Variegated Landscape of Mediation. They looked at 60 countries. They looked at every single member state of the European Union, and they analyzed using, I think it was 28 questions, what is the similarity and what are the differences in mediation. And they were hoping to find out of these 28 factors, at least one that all countries would share in common, such as confidentiality. Does not exist. The entire book will let you to understand that every country, the word mediation exists, but we are divided by a common word because our understanding of the word is different. What does this mean for India? It's got to clearly develop its own use of mediation. It's got to work out itself. However, and for me, this is where the grass is greener. I look at India and I'm much more excited. Why am I more excited? Because I see your judiciary getting involved in the discussion. They understand the need, and for them the solution is, let's not pour more money into more courtrooms. They are struggling with the idea of letting private sector initiatives or court annex mediators who are not subject to the court's jurisdiction to go out and do things. But I'm hearing incredible experiments in central India, South India, north of India, really exciting new developments in the field of mediation that are happening. My concern for India, if I might express one, is that it will develop too fragmented region by region. I think it's a hugely important moment for all of this leadership to get together and try and at least have common standards. Create something a bit like Singapore has done now. Singapore, tiny country, how can you compare the two? But Singapore has set very clear standards that are almost self-imposed standards for how do we want to work as a community of mediators. And I invite India to do the same thing, because if India, with its plurality, with its variability, with its cultural diversity, to be able to come together and create access to justice that responds to people's needs in ways that are really done in that, openly by people working together, I think we'll be seeing a system where people will be coming to India to learn from India about the changes that you are already doing in some of the cities, or I'm aware of some of the programs that are going on. So I'm looking to India to be our hope for the future, because for me, Europe right now, not as good as I think Anuroop, you were painting us to be.
Taking a cue from what you said, Jeremy, about the differences, the culture, and also the differences in the mediator. And coming back to the theme of this discussion, how important is the nationality, cultural sensitivity, and commercial exposure of a mediator in multi-jurisdictional disputes like the ones that may emerge between Indo-European Union businesses?
So there are huge differences. I've done probably 14 basic introduction to mediation trainings in probably 10 countries. Each one has been completely different. In some countries, I was told you must caucus immediately. In other countries, I was told you must never caucus. If you caucus, you can't call it mediation anymore. Call it something else. In other countries, I was told you must do robust reality testing. In other countries, I was told very different approaches on what the concept is. There's a lot of culture that is underlying. That goes back to the comment I was making before about 60 states divided by a common word. They're all using mediation, but they do not have the same understanding of what it means. Yes, at some level, it does mean an amicable form of resolving conflicts. However, what is the status of that neutral? Is this an expert or not an expert? Do norms apply? Do they not apply? Do you, how do you work culturally? How acceptable are emotions? How formal is the process? How do people engage? Are we influenced by a legal prior practice, or coming to this as an engineer or a therapist? Are these short interventions of 1.5 hours? There are huge differences, and yet here we are today using the internet. So let's even talk about the internet and online dispute resolution for a moment. I would say that until the coronavirus pandemic hit us, 90% or 95% of established mediators would tell you, you can't mediate online. You lose the human contact, you don't have the feeling. It's all about people as people, and you need to be there physically, and we need to have our scripts and our rituals and bond together and find solutions. Now that we have no choice, I'd say most mediators are discovering that, wow, you actually can do a mediation online. Or not only mediating online, but even arbitrating online. I've done a full arbitration online in one case. I think we need to revisit a lot of our fundamentals. It's what His Excellency was saying before. We need to think about the paradigm and change the way we think about all of these things. We have our innate kind of fears and our beliefs that, yes, I do believe that a face-to-face mediation will be better than online mediation in most cases. But on the other hand, I think that an online mediation is far better than no mediation at all. And so we need to be looking at, what are we comparing here? Are we comparing apples to apples? So there are huge cultural differences. That book shows it, that I was mentioning before. You can take a Riskin grid, if you know what I'm talking about by the Riskin grid, how evaluative the mediator is on substantive issues as one axis, and the other one being how directive they are on procedural matters. And you'll see that there are different themes in different countries. And there's a lot of that personal culture of the local city or country that will come in to influence how it is. And I can tell you that California in the United States is very different from Texas or Florida or Boston, even though they think they're all there practicing the same mediation. It's not. So their cultural variety will always exist. And I think it's for us to kind of transcend ourselves and incorporate cultural diversity into what we do as mediators. And that's what we need to do by, I think, more designing and defining the process to meet the cultures of the participants, not the preferred style of the mediator. This now might lead us into a discussion on ADR hybrids, which I saw somebody was asking a question about, but it's really important to understand to what extent the disputant want norms to apply. To what extent is the neutral meant to be an expert in these norms, or able to at least generate the norms or have a discussion around the norms or apply the norms? If norms do not apply, however, then that needs to also be understood. And what if you want both? What if you want combinations? We know co-mediation can be extremely effective. Your average arbitral tribunal for an important commercial case will be 3 people. I'm astonished by how many people have no problem putting a 3-person arbitration panel. But the moment I suggest co-mediation for 2 people for an even larger dispute, they'll say, but why not? Why do you need a second person? So I think there's a lot of things to think about here. If we're looking to a future where we will have more transactions between India and Europe, whatever Europe means, because I'm from Switzerland, we have 26 cantons, and each canton has its own country and culture. So, for me, Switzerland is a mini European Union to some extent. European Union is not one culture, one country, but you can obviously say that's not the case for India either. How many languages does India have? How many cultures does India have? So, how are we looking at these things? The truth is, if we did want to do more more commerce between Europe, whatever that means in India in its larger sense, we would need to try and work on this and understand how we're going to do this through co-mediations, through people understanding the different cultures and being able to work at teams. And I think that's where the future might hopefully lie, but people don't want to be mediated, is my sense. How do we grow mediation? I think unless there'll be some very tough impositions on what might be perceived as non-voluntary mediation, non-voluntary in the sense that you're obliged to go to mediation, but it will still remain voluntary in that you can end it. You can walk out at any stage. And that's where I think we need to redefine what voluntary means in mediation. It's the freedom to leave the room, not necessarily the freedom of choice of going into the room. But if we are able to think of these things and change it, that's where I think we'll be able to make a major shift in paradigm and change things, because for the moment, I'm not very optimistic about very significant changes. Although we have the technology with the people, we have understanding, it's faster, cheaper, better. We're even looking at neuroscience, understanding the human brain and how much better is mediation compared to even negotiation. We have some studies now. It's just not happening, and it won't happen, I think, without some state intervention. So sorry if I'm sounding a bit depressing on that topic, but I think it's my perception in any event.
Thank you. Anuroop, I'll ask the same question to you, and also like considering what Jeremy said, that in India, there could be a chance where we can have 4 different types of mediation, be it like, South India, Central India, North India. How important is the nationality, cultural sensitivity, and commercial exposure of a mediator in multi-jurisdictional disputes? And I would request you to keep it a little short.
Siddharth, I missed out a bit. I think I missed out a bit. Maybe there was a little instability on the internet connection side. But what I remember, just summarizing for my own clarity and understanding, is the question is specific to how important is the nationality and the cultural sensitivity when it comes about mediation, and how important is the person's individual experience of commercial transactions or commercial dealings. So let me put nationality and cultural sensitivity in one basket, and let me give you a context around it. The trainings that have been happening in India, if you go to the basis, you will find the modules or the kind of teaching that you have been adopting is primarily based on the Harvard PON project, right? But if you look at both the cultures, it's a way more straightforward culture, right? Indians by nature, we are avoidance. It's a rarity where you can think of, I and you have a conflict. I pick up the phone and say, Siddharth, let's sort it out. We primary, not demeaning against, because I myself being an Indian, we are like ostriches. There is a conflict, let's stay away from it. Let's, brush it under the carpet. Someday some magic has to happen and it will get sorted, right? So given that what Jeremy said, we need to rethink. There has to be a mediation, learning, reflection, where we need to revisit and see how much of it has to be Indianized. That's point one. Point number two, yes, cultural sensitivity plays a big role. Like, I am a terrible failure when it comes to mediating a matter between two women. I am a terrible failure when it comes to mediating matters pertaining to a particular segment or say a particular tribe which I have no understanding of. So cultural sensitivities are very important, because you understand how to connect to the parties in the conflict. Because when a mediation is taking place, it's not about legal jargons. It's not about just, the magic of using the mediation skill set. It's about analogies. It's about anecdotes. But unless and until you understand the culture, creating an anecdote, relating to an anecdote cannot just come from, doing a quick research on Google, which we are acquainted with. So yes, nationality and cultural sensitivity, my one experience having mediated one matter for a Japanese client, he point blank said, we are willing to go with mediation, but you need to have a Japanese co-mediator, because though we understand that you understand law, but we aren't sure how much you understand our Japanese way of resolving conflict. So it's extremely important. Now coming about commercial exposure, again, as Jeremy said, the grass is always greener on the other side. India's history of mediation is quote annexed. What we are seeing as private mediations, what we are seeing as private institutional mediations is fairly new. Now there is a big question, and there has been big issues around it since long. who are the mediators in the country? How many chartered accountants? How many professionals? How many architects and mediators? Mediation market is predominantly dominated by lawyers. The reason being, it has been court annexed. But what I personally believe, ADR neutral, it's primarily the litigators who have ended up taking up mediation as a practice. So I think for mediations to be more effective, more successful, to spread of word of its own, all those mediators need to also understand how primarily a commercial transaction is concluded. Because when the transaction is born, that's where the seed of dispute or the seed of no dispute exists. So we need understanding of how things work. Like if you are in a maritime trade, if you are in a maritime arbitration or mediation and you don't understand how the maritime trade works, you can't effectively resolve it through mediation. So yes, a great amount of commercial exposure is required. And as Jeremy pointed out, if at this stage we don't work together across India, it will have various fragmented mediation practices across different states in India, just as Jeremy is pointing out has happened in Europe.
Thank you.
If I may just also just to give you a very quick example of how this is, let me just do a quick screen share with you, if that's okay. I just want to show you how common this is. So on my website, basically, I have, and I hope you can see my screen. Are you seeing the screen? Then there's a place called useful information. I have a button here because I'm always looking at different cultural dimensions. So let's say today we're going to have a mediation. This is the Hofstadter, so you might know these dimensions already. But if I just say I want to have a mediation between an Indian company and I want to have a Czech company, and I then want to have a Swiss mediator maybe, and I do that, we can already see just visually that on certain things we will be different. And the mediator also is part of this danger. Because if you just look at whatever these graphs mean, and you don't need to understand them, visually you can see some differences. I'm not sure, Anuroop, I would agree that India is more about avoiding conflict or if that's what I thought you were saying before. But I do think Indian is much more high context as a culture. So many things that are there are so important and picked up on and read that Westerners are completely oblivious to and blind to. So the puns is coming from a low context culture. How can a high context culture adapt and appropriate for itself a system that is based on low culture kind of paradigm and mindsets? Very difficult. And that is why India will need to come up with its own approach. But we also know, as you said, there will be regional variability, but understanding this and allowing for it and building it into the system should be there so that when you have a certain type of conflict in Mumbai, you can say, well, I actually want to go and get a mediator from, it can be anywhere else in Mabalipuram, whatever it might be. And you might say, this style for this type of case might be useful for us to understand that what can be brought in for the values, the type of the dispute that we have. And I think we need to understand that diversity and we need to manage it. Sorry, I'll stop sharing my screen. But I think these are the things that are important for us to think about. The technology is there, we can use these things, we just have to incorporate it into our thinking. But it is very important.
You're right. I have, considering the differences, and now as the world is becoming one, Jeremy, my question is to you. Do you think that the implementation of the Singapore Convention will assist Indian and European Union businesses to receive the right kind of mediation and services?
Again, mixed feelings on this one. The answer is to some extent yes, and already. When you see that, I think it's now 53 states, member states have signed it. It's already been ratified. It will come into effect in September. It is coming to stay. However, again, why has not a single Western European country signed up on it? Yes, Europe might say, the EU might say, well, this is a matter of EU policy, we need to concert ourselves, and so all the member states will go in at the same time. But it's not so simple. If we do have Brexit, will the United Kingdom immediately go and adhere to it? There have been very few common law countries comparatively that have come on board as well. Clearly, there's a need for the Singapore Convention. It makes people understand mediation, and I've had more lawyers come to me since the Singapore Convention saying, what is it, what is mediation, and how might it affect my practice, being arbitration in most cases. But I think it's more the fear of mediation right now that is creating questions. It's not necessarily yet desire. It's not the desire of the disputants to use mediation. It's not the desires of counsel who feel very familiar with the roles of mediation. Some of them still see mediation or ADR as meaning alarming drop in revenues. They don't see it as simply a much better, faster, cheaper way of building better relationships with their clients who want to stay with them long term and use them for their soft skills as much as their legal skills. I think there's a lot of elements here, and that I think we're far away from it. So Singapore Convention, yes, I'm a huge fan of the convention. Very important to have it. We have China, we have the United States immediately signing up on it. With India, these are big changes. But the proof of the pudding is in the eating, and I don't see many dishes with mediation in it yet.
Anuroop, I will ask you the same question, and I'll add something else, and this will be the last question. And after that, we'll take question and answers from the participants. Like, again, do you think the implementation of Singapore Convention shall assist Indo and EU European Union businesses receive the right kind of mediation services? And the add-on question is, the Singapore Convention is the first UNCITRAL draft that gives an indication that the world is ready to give prominence to mediation over conciliation and arbitration. But in India, there is still confusion on the law. Can you also throw some light on the confusion and what should be the way forward for Indian jurisdiction as an upcoming global dispute resolution hub?
Yeah, so definitely, Siddharth, as Jeremy said, the carrot is here. That's the Singapore Convention on Mediation. Now we need to understand how to chew the carrot, right? So in India, there has been various talks. Someone is saying, why not amend 89 Civil Procedure Code? Someone is saying, why not have a standalone Mediation Act? So just as Jeremy said, we have added a little bit of confusion, but in the interest of mediation, in the interest of conflict resolution, I think this was a much needed step. But as Jeremy pointed out, it should not work out based on the fear that counsel or parties have pertaining to mediation, but it should work out in a manner when the right kind of advocacy penetrating into the minds of people who are into conflict to understand the essence of it. Because mediation honestly is not just an alternative, it's an appropriate mechanism. But something to be called as appropriate, you need to understand the essence. You did not use it out of fear. You did not use it out of the fear of a statute which works like a stick. People need to internalize it. People should, just the way we have learned to stay at home for 2 months, we need to know how to live with mediation for years to come. So it will lead to a cultural shift. And as Jeremy said, I think the last one to sign few days back was Saudi Arab. It will lead to a lot of growth. But again, the issue is just an international convention won't make sense, because again, we had a UNCITRAL convention on arbitration, but India, to see the light of arbitration, it took ages. So I personally believe India, having taken a step forward much before Europe, let's put it, we have a edge here. Europe has not gone and signed it. Yes, let's use it conveniently and position ourselves at par with Singapore, or if not Singapore at par, let's be the next best option before London, Paris, and Switzerland takes over as the dispute resolution hub in terms of mediation. Because three very developed and emerging economies which have signed it is US, China, and India. US mediation is a well-developed practice. India needs to buck up, pull up its socks, and bring it. But yes, it's a great thing that could happen. You know, I would honestly say my prayers for last 8 to 9 years have worked out. There is a convention on mediation, and I am extremely happy about it.
And we are all waiting to have the pudding.
Yes.
As said by Jeremy.
And coming about your question on mediation and conciliation, I think conciliation has been there in India through the Arbitration and Conciliation Act. I am of a personal view when you categorize mediation as a facilitative or evaluative. So I put conciliation as an evaluative form of mediation, and I put mediation as a standalone facilitative way of dispute resolution. So in India, if you see, being a little avoidant culture, facilitated mediation is a kind of conciliation which we have been using. You know, even experts like Sriram Panchu admit that we completely don't use evaluative form of mediation in India because it does not work out. So the Indianized form is a combination of facilitative and evaluative mediation, which is a part conciliation and a part mediation. So yes, after this, I honestly don't care whether there is a distinction in conciliation and mediation apart from it in being a theory in the book, as long as the peaceful mechanism of conflict resolution is put to use for resolving commercial disputes well within time, with limited budget, and most importantly, we need to survive together. That's the need of the hour. So no conflict should lead to a situation where we part ways. Conflict should come up. It's as natural as deaths and taxes, but we need to know how to reinvent ourselves out of the conflict situation to be stronger and better.
If I may just jump in very quickly on one thing that is very important, though, and I think it is particularly important also, my foreign perspective, excuse me if it's wrong, in the Indian context. Conciliation, mediation, is it just about evaluative, not evaluative? We're focusing there on the substance. We're not looking at the status of the individual. If I look at the traditional system of the village panchayat, right, and you're looking at this idea that you're going to get a person coming in, this person has authority due to their age. India has huge respect for its elders. It has huge respect for certain people. When your judges walk into a room, you do not get the same impact in other countries. These are key cultural differences as well. So when a person who is looked up to, who is the elder of the village, comes and says, can you do something? Can you try something? Even if they're not applying norms, there is much more of a collectivist mindset culturally in India, and there will be the desire to please the person who has that cultural aura and has that, that position. To some extent, though, it drowns real needs and interests. People want to adapt to social cohesion and harmony, and so they will not go into their private interests and needs because they don't have that opportunity of maybe a caucus or what might be needed for face-saving purposes. So I would just be very cautious when we think of just leaving it out there. If we want to give true informed consent to disputants, we need them to understand also what pressures will they be under. And if we remove all pressures, we need to make sure that the people we bring in are not necessarily people who are looked up to, but are equals, or people who are there to serve. And I think it's just something that we should be sensitive to, because there's a lot that can happen. I've seen this outside of India and other cultures where I've done mediations. The perception of the person coming into the room is also a very big thing. You are coming into the room as a barrister or as a silk is different in certain mediations than if you're coming in simply saying, I'm a US attorney. I have both titles, and I'm astonished to see the impact it has on people when I say in one case, yes, I'm a Swiss lawyer, or else I'm a barrister. It changes the perception of me completely in some cases, and it makes no difference. So I think we really have to not underestimate the importance of these things. So I just wanted to add to Anuroop's excellent expose there.
Thank you so much. Now, as you know, we are running out of time. I'll just take a couple of questions from the participants. And this one question for His Excellency Milan Hovorka, and also to Jeremy Lang. Just a minute. Yeah, From an European standpoint, how popular is mediation today for cross-border commercial disputes, and how can it be more popular? His Excellency.
Thank you very much. Thanks for the question. Can you hear me? Yeah, thank you so much. Definitely being part of the European Union, this issue has become increasingly important, but at the same time, I would fully concur with what Jeremy has been saying, that it's quite a mixed picture. And despite the fact that we have made tremendous progress to promote mediation, I think that still a lot of work has to be done, and definitely we do have different kind of processes, procedures to encourage not only businesses to solve their differences through mediation and without taking the issue to a court. And definitely we are also promoting mediation by introducing into the Czech civil procedure code the possibility for the court to order a so-called first meeting with the mediators. And then definitely it's up to parties to decide whether, as Jeremy has said, whether they want to enter the room. And there is yet, I believe, another important aspect of mediation. We haven't talked about that. And it is about out-of-court settlement of consumer disputes. And I believe this is also quite important aspect in which eventually Europeans can share their experience and work together with Indians. So this would be my answer to the question. Thank you so much.
And I would say, you know, in addition to that varied landscape that we have, let's just look at it today. If you are a Czech company and you're an Indian company and you're doing a contract, how much time is going to go into thinking about the dispute resolution clause? For most lawyers, it's going to be a template. It's the standard clause they'll put on the end. The average argument will be, well, do we want to have the Czech courts or do we want the Indian courts? And they'll go back and forth and talk about the unfairness and the languages. And they might say, you know what, let's take a neutral form. And I think the discussion will be more today still towards, shall we use English law, Singaporean law, or some other kind of, you know, system that is going to be acceptable as a neutral compromise, still thinking of a neutral jurisdiction. Arbitration, I find, is still very difficult to sell because many people are afraid of arbitration. They think it's hugely expensive. It's going to take a long time. Certainly, institutional arbitration in some cases. I mean, ICC, many other places are trying to deal with this by being a lot more, you know, they're putting very clear rules on you have to communicate, you've got to meet your deadlines, you've got to meet your budgets. I think they're all trying to improve that, but the perception is there. It's either an unnecessary step or an extra expense to what is going to be inevitable. And so, or it's grounds for delay, or it's a sign of weakness. I work with some startup companies. We try to put mediation arbitration clauses into all of our contracts. I like hybrids, so I do mediation and expedited arbitration. The idea being that it's a sole arbitrator and it'll be rapid justice to really resolve the issues that we could not deal with in mediation first. It's cost effective and makes sense to any corporation. I'd say around 8 cases out of 10 I get pushback on the clause. It's a standard. I use WIPO because it's a software agreement. So it's an international United Nations agency. It's got no sense of valency. I can put any law, I can put any city, which would be the seat of the mediation or the arbitration. People do not like it. So I think that's the other reality for where we have to go. And so my invitation to India, and Your Excellency the Czech Republic as well, would be think of don't be afraid of actually going in for compulsory processes, because people will not start to use mediation and start mediation clauses voluntarily until they feel familiar with what mediation is. And familiarity does not come through education in law schools. It does not come through education in business schools. It might come through education in high schools, but it's not being taught there as something. It will come through actually experiencing it. The mediators I know who are the greatest fans and supporters of dispute resolution, appropriate dispute resolution, as you wisely call it, Anuroop, are those who've actually been through it, not the ones who are simply reading about it in a textbook or to pass a bar exam. So I think that until we actually have practice, it's a kind of a cause and effect, and that's where the change is needed, because I don't think Europe is doing a good job of that right now.
Yeah, thank you so much. We do have more questions, but I believe, like, as we are already, we have crossed our time, I think we can answer those questions offline and we'll email it to the attendees. I would now request His Excellency Milan Hovorka for, vote of thanks and conclusion.
Okay, thank you so much. And as you said, we are running short of time, but still a couple of words. First, thank you to Jeremy and Anu for their excellent insights. Jeremy, I thank you very much for greeting us both in Hindi and Czech. Highly appreciated. Definitely, we learned a lot, and I believe that thanks to you guys, we have been able to understand better the potential of mediation, and definitely factors that have to be taken into account if you want to promote it. And definitely that we will have also to be able and ready to change something in our mindsets. And I believe that there was yet another question put by Gunit Chaudhary, to whom I send my best regards. By the way, Jeremy is from Chandigarh, because you mentioned Chandigarh in one of your previous interventions. And the question he posed was the negotiations and mediation will be the only future for corporates. I wish he were right, but I believe that also from the discussion, it has been crystal clear that we have not yet reached that stage. And definitely, I am also grateful to both Jeremy and Anu for bringing out today's discussion into somewhat broader perspective, that we also had opportunity to talk a bit about well, the concept of thinking locally and going globally. I think extremely important, and that we also could address the importance of the European Union India strategic partnership. And when referring to the European Union, Jeremy, definitely I do have also in mind a cross relationship Switzerland does have with India, and definitely with the European Union. And Siddharth, thank you for being a great moderator. You have done an excellent job. Should there be any question still not answered, I'll be definitely more than happy to respond to them in writing. Overall, a great experience, And I believe that we will have another opportunity to do something together in the future. Thank you. Take care.
Thank you all.
Thank you. Thank you all for coming. Thank you all for your time. Thanks a lot.
Thank you.
Thank you all the attendees as well. Thank you.
Thank you so much.
Thanks a lot, sir.
Thanks.
Thanks a lot for your time. Thank you.